Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel and Elizabeth. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
The CHIPS Act and other global pressures have spurred construction of new fabs across the United States. There's even one a couple hours drive from where I'm currently sitting here in Buffalo, New York. That means hundreds of millions of dollars in construction and new equipment, but those pieces may not be the hard part. Eventually, those fabs are going to need people, a lot of people. And the location is not always selected as somewhere with a large technical workforce to draw from. Even if there is some workforce, listeners know that the semiconductor talent pool is only so big, which had us thinking, what will happen when a human resources team starts its hiring bonanza for these new facilities? You have people with existing agreements and restrictions like non-solicit and non-competes. You've got all sorts of relocation concerns. And new fabs can't just build a university program to create a talent pipeline fast enough to meet the end of construction. At least probably not. So what challenges will HR professionals need to navigate so that these new fabs can open on time? Today, we're joined by my colleague, Andy Drilling, to talk about what he expects to see as these new fabs start to grow. Andy, thanks for joining us today. Could you give a quick introduction to yourself and talk a little bit about your experience?
Yeah, sure. Thank you for having me. My name is Andy Drilling. I'm a senior associate in the labor and employment group here at Hodgson Russ. We deal with a whole host of labor and employment related issues, everything from onboarding, which of course will be particularly relevant to this conversation, up to and including, the efficient and successful termination of employment when necessary, and everything that goes on in between, as I'm sure we'll be talking about, when you're bringing on employees, particularly a large number of employees in a relatively short period of time, there's a whole host of issues that can arise. So we have a lot of experience working with those throughout my 10 years of experience in labor and employment. And I also have a background in litigation. I litigated for a couple years prior to transitioning to a purely labor and employment. So I have a good litigation background that I can tap into in dealing with some of these issues as well.
Andy, it's great to meet you. Thank you for coming on our show today. I think you and Nathaniel kind of already touched on this a little bit, but just queuing you up for the first question here. When an HR team starts out and is working with a semiconductor fab that's maybe becoming operational, what are the things that they need to be thinking about? And what are the issues that are going to come up probably first for them?
Thanks for having me, Elizabeth. And that's a good question. A lot of what comes up here is, at least at the outset, right? A lot of these places are starting to build from the ground up, and they've got to move, and they've got to move quickly, particularly, since COVID-19, we've seen a lot of issues with the workforce and the trouble with onboarding employees, particularly in technical positions and things like that. So these companies have to move quickly. There's a talent shortage, both generally in the U.S. and throughout, in particular locations and locales as well. So they'll have to be aware of that, and they'll have to move relatively efficiently. But they need to do it also being mindful of both, federal, state, and local conditions and laws that implement their workforce, and that will make it perhaps more difficult to efficiently onboard these employees, locate and hire and onboard the employees within the period of time that they would at least prefer to do so. So I think really what we're looking at here is a talent shortage, and then also the practical, administrative, and legal issues that arise in onboarding these employees relatively quickly and being ready for operation in an efficient and quick manner.
I'm sure we'll get into some of the specific issues, especially around the state and federal law piece. But to set the stage a little bit, are there specific pain points that an HR team faces when they're trying to add hundreds of technical jobs on such a short time scale?
Yes, there would be a lot. You would want somebody, obviously, with some boots on the ground and some familiarity with where this is going on and where you're trying to onboard all these employees. If you're kind of coming Let's say if you have a presence in California and you decide you're going to engage in one of these endeavors in a new state, such as New York, you will be working kind of off a blank slate. You're going to have to learn what's going on both in the new locale and any restrictions there might be on hiring, onboarding, and just the day-to-day operation and management of employees. So administratively, there's a large burden here, and you're going to want to make sure you have a good HR team or you're partnering with people in the locale where you're going to be opening to make sure you're aware of exactly what's going on, what your requirements are going to be, and to make sure you're staying on top of those. Turning to the legal issues, there are a whole bunch of legal issues that arise that are separate and apart from the administrative issues. Just from a practical standpoint, here in the U.S., as an employer, you're governed by federal law. There's certain federal law requirements that are going to apply regardless of where you're located. So you need to be mindful of those. And if you have a previous presence somewhere in the U.S., you're probably somewhat familiar with those. But there's also state and local requirements as well. And those often overlap. And you need to be aware of those because, for example, a state or even just a locale like a city or a town could have different requirements that are more onerous than the federal requirements. And you're going to need to be aware of those and comply with those as well. So, for example, where we see that a lot is in the world of onboarding employees, at least there's pay transparency requirements you need to be aware of. Here in New York, even if you are just planning on hiring employees and you're advertising for positions that could theoretically be performed in New York, there is an obligation to include salary information in those postings. So this might even be before you get your boots in the ground on New York. You need to be aware and mindful of some of these other obligations. And then once you do that, you need to continue to stay on top of everything because once you start actually onboarding these employees, especially if you're doing a large number in a short period of time, there's going to be all sorts of issues that arise, and federal, state, and local law are going to play into all of those issues. So you need to be aware of those as well.
So how about specifically for maybe skill shortages? I could see how, and maybe this plant that's coming in kind of near you guys is a little different than if a plant came in near me in Silicon Valley, right? Are there ways that companies could be partnering maybe with local universities or educational institutions and trying to get the skills that they need kind of put into the curriculum in hopes that those, freshmen will graduate in 4 years and maybe that's about the same time that these fabs are opening, is that a technique that people are looking at?
That's a great suggestion, Elizabeth. And I think that is an efficient way to go about doing this. It will depend, obviously, the extent to which certain universities are willing to work with you and tailor their programs to meet the needs of any one particular company or even one particular industry. We have seen some companies have some success with that. And that might be easier perhaps at smaller universities, technical schools, things of that nature. Certainly large organizations and universities could also be open to that, but they might have additional restrictions, bureaucracy that they'll need to work through. So they might not be as flexible. But that is certainly a good way to go about trying to deal with these shortages and trying to establish a pipeline. It might not work in all cases. Take Clay, for example. They are near Syracuse, New York. So they have the University of Syracuse and other local institutions. They're lucky as well because they might be able to tap into other local universities. And I'm using local relatively broadly here. They might be able to send their reach down to Rochester, to Buffalo, where there are additional universities and technical schools and things of that nature. So they have a wider pool of potential sources that they'll be able to reach out to and draw from and hopefully develop working and cooperative relationships with to tailor some of these programs and things of that nature.
I have a friend, so I'm dating myself here now. I had a friend who dated a friend of mine in college who went to GMU. I don't know if that even exists anymore. But my understanding at the time anyways was that, GM had sort of created this university that was essentially specifically as a pipeline into the jobs that they needed. And do you know if any semiconductor companies or, that are beneficiaries of the CHIPS Act have thought about something kind of that radical rather than working with universities that sort of already exist?
I personally have not heard of any of that, and Nathaniel can jump in and correct me if he's, or let me know if he's heard of any either. But that is also, like I said, a great idea. We shouldn't leave any stone unturned here, especially with the talent shortage and supply shortage as far as talent goes here. So to the extent these companies can work together with local universities, technical programs, what have you, to develop these relationships, that is certainly something, we would encourage them to do. The goal here is to hit the ground running, right? And that way you'll be able to do that a little more efficiently than if you're taking new hires who are a little, green around the ears, not necessarily have the training and skills you need. We have worked with some clients in related industries who have shared that sometimes, hiring people fresh out of school can be a challenge. There's more of a learning curve there than they would like. So if you can tailor programs, certificates, what have you, to kind of hit the ground running and get a better supply of the workforce, a learned workforce into your facility, at least from a labor and employment perspective and a practical perspective, that would seem to have a lot of efficiencies and benefits associated with it.
Yeah, and I also am not aware of any specific initiatives beyond what is going on at Purdue, which is setting up a separate major related to semiconductor technology, but that's not tied to any particular employer. And lots of potential employers got behind that initiative.
And something else, if I could just jump in there, something else that, these companies consider doing is establishing, even if it doesn't go quite as far as, a formal program, as I think you were indicating, Elizabeth, something they could do is establish their own internship programs that would draw people not only from local universities, meaning, pretty much any university in New York, if you want to extend local that broadly, but you can also try to attract students from other universities that have, the relevant skill set and credentials that you're looking for. Use that as an opportunity to bring them into your facility, to appoint them to your organization, to let them see what it would be like to work for you, what it would be like to work in a specific locale where you might be trying to recruit and attract them. And that's kind of a way of getting these folks in the door, getting them some practical knowledge. So that way, if you are hiring them, you're not necessarily doing so with a blank slate. And you might see it a little more efficient of a transition there once they're actually out of these programs.
So assuming that we don't set up a new major or new certification program at a university and don't just found a new GMI Kettering University equivalent for semiconductors, then that means we're probably having people relocate. What kind of problems are inherent with onboarding large amounts of workers that come in from out of state or from the other side of the country? Skipping immigration issues, let's just keep it simple to U.S. only. You're pulling people from the other coast. And what does relocation and onboarding mean for that, for a large number of new employees?
Yeah, so there's the practical problem, right? Of we have to get in front of these people. We have to have them hear of us. We have to, assuming we're successful, get them to agree to come and work in a different location and figure out how we're going to handle the transition for each specific employee. But once we do that, these individuals either might be they might be new graduates, or they could be experienced professionals. So they might have a background knowledge of, working in the industry, or they may not. So once they get into our company, or once they agree to come over, we're going to want to make sure we have established policies and programs in place so that once they get here, we're able to hit the ground running and allow these folks to understand what's expected of them, how things are done, and to have an efficient and smooth transition there. So one thing we see when you're hiring a lot of employees in a relatively short period of time is there's a couple of things you're going to want to keep in mind. First of all, we need to make sure not only that we have the relevant policies and practices in place, we want them to know what's expected of them, and we want our boots on the ground, our HR managers, our supervisors, and things like that to know how we expect them to manage these employees. But there's also a lot of things we need to be mindful of on the HR and legal side. For example, right out of the gate, you want to do a couple things, like make sure you're properly classifying your employees as exempt versus non-exempt, as employees versus independent contractors. That has a host of potential ramifications, including unpaid overtime, minimum wage, and things like that. So that's something you want to make sure are clear and upfront with the employees right out of the gate, and that you get it right. If you don't, that can create a lot of headaches if you have to go back and try to administer this backwards and correct any mistakes or perhaps ambiguities that may have came up in that process. So I'm not saying you can't do that. You certainly can, but that is something that is very helpful to make sure you're getting right out of the gate. And of course, employees want to know that. What these employees are going to be interested in is, their salaries, how they're being paid, and things like that. And especially if you're recruiting them from different states, different locations, we need to be upfront, and we need to make sure we're sharing the relevant information with them immediately. Also, when we're recruiting and attracting people, we want to make sure we're doing it in a non-discriminatory manner. Discrimination can be both intentional or unintentional. So in some cases, if you look at your talent pool and all you're attracting are white men, for example, that might indicate that you are drawing from, you're not considering all of your full sources, or that we should be looking at more diverse places and more diverse avenues to recruit talent. And that would also have, the benefit of enlarging the potential talent pool, since we've acknowledged multiple times how there's a talent shortage in the industry and nationally. Another thing we want to do is make sure, of course, we're onboarding employees, right? And nobody likes to spend the time and energy to retract and onboard an employee, train them up a bit, and then have it not work out. So while we need to bring people on and we need to make sure we're doing it on a large scale and doing it relatively efficiently, we also want to make sure we're attracting the right talent and we're doing it in a lawful way. A lot of the laws, both federal and state, and sometimes even local, regulate the extent to which you can conduct background checks and drug tests and things of that nature. So it's very important to make sure that you're aware of those requirements on a federal, state, and local level. And even though we need to move quickly here, we want to attract the right people, that we're doing it in the proper way. For example, in New York, the New York Department of Labor has taken the position that employers in most industries, absent any unusual circumstances, should not be testing employees for the presence of marijuana. If you're not a New York employer, you might not necessarily be thinking of that, and you might be regularly testing your employees for marijuana. But if, for example, we subject 500 people to pre-employment test drug screenings that include a marijuana panel, and we don't have a good reason for doing so that would qualify under the law, you might find yourself in a host of problems facing a class action lawsuit. So, of course, we would prefer to avoid that if we can.
What about non-solicits? So I think, especially if you're looking at someone who has been employed somewhere else before, right? Not a new college grad, is fairly common for offer letters in the tech sector to have this non-solicit. How can an employer navigate around non-solicits, especially when they're in need of this large and hopefully already trained workforce quickly?
Yeah, sure. Non-solicits pose a unique problem. And I just want to be clear that right now we're talking about non-solicits and not non-compete restrictions. I believe we're going to touch on that shortly. So both of those, however, present unique considerations in that, if I'm company X and I need to hire 500 employees in a jurisdiction in any state, I'm not necessarily going to know whether or not all these employees are subject to a non-solicit or some kind of other restrictive covenant. That somebody comes, the first thing they're going to say to you in an interview or something like that might not necessarily be, I'm subject to a non-solicit. And depending on the sophistication of the workers we're looking at, some of them might not even know they're subject to a non-solicit or might not understand the importance of that. So as an employer, what you really want to do is be proactive about this. And when you're onboarding employees, we should have a plan in place, right? Hopefully we know whether we're going to ask them to sign employment agreements, which generally is for higher level C-suite employees, or have them sign some kind of offer letter or other acknowledgement of employment. So I would recommend that in all cases, even for line workers or things of that nature. If we're not going to go as far as an employment agreement, we should certainly be considering some kind of offer letter or something that documents the nature of the engagement. And what you want to do with regard to non-solicits or non-competes or other restrictive covenants is include language directly in there proactively to protect you, the employer. And that could say something along the lines of, depending on the circumstances, should probably include a representation that they are not subject to a non-compete, are not subject to a non-solicit, that joining your company will not cause them to violate any agreements to which they are already a party, and things of that nature. And what we hope to do there is that's not a foolproof plan, you could still find yourselves in some trouble if you're helping an employee, or if you inadvertently help an employee violate a non-solicit or a non-compete. What we're hoping to do is, one, provide some protection that we would have potentially if it's an employment agreement or something like that. You could have a potential breach of contract type of claim or defense. But really what we want to do is draw out from these employees, are there any agreements that you're subject to? If there are, what are they? Let us know about it. Can we see it? And then what we need to do is take a really careful look at that. There are state and federal restrictions on non-competes and non-solicits, more so non-competes than non-solicits. But as the state and federal government is becoming more adverse to non-competes, there's always been some hesitancy there, but there's certainly more developing adversity to both non-solicits and non-competes. We're seeing a lot of more non-solicits being interpreted and enforced in the same manner as non-competes. So non-solicits may suffer from the same kind of deficiencies and legal defenses that a non-compete also would be. That's not always the case, but we are starting to see that. So if an employee does tell you I'm subject to a non-solicit, that's not necessarily the end of the day. We don't need to let that employee walk necessarily, but we would want to see the agreement, better understand the restrictions, and understand what we might be getting ourselves into if we continue to pursue an employee who is subject to a restrictive covenant, such as a non-solicit or a non-compete.
I want to ask specifically about non-competes because that's a hot topic. But before we get to that, I have a non-solicit question. What do you do as the employer if you did onboard great employee and great employee says, hey, I've got a whole team of people back at my last company that I would love to have come work here. They're not happy. Let's have them move over here. But that new hire is subject to a non-solicit clause from his previous company. I mean, how do you navigate a situation like that when you can see the exact team you want, but you can't ask for them to come over?
Yeah, that's a great question. And I think that would be particularly frustrating for somebody in, the shoes of our hypothetical company we're talking about here to deal with, because they see that large workforce that they need, that they want, that they would hope to attract and retain. And there would be some appeal, I would think, to being able to, port over a whole already functioning working group or team. That doesn't, just because there's a non-solicit at play doesn't mean necessarily, you're dead in the water or dead on arrival and there's not anything you can do. Like I said, I would want to get my hands on that non-compete or the restrictive covenant, whatever it is, non-compete, non-solicit. I'd want to see what it says. I'd want to see what those restrictions are. Maybe we're in a place where we need to wait a year for the non-solicit to run before we can start soliciting employees through this individual. And there are, of course, different kinds of non-solicitation agreements in and of themselves, right? So some agreements only extend to non-solicitation of customers and clients. Some extend to non-solicitation of employees, and some cover both. So I'd want to make sure we know exactly what we're dealing with. Again, employees subject to these agreements are often given them and often sign them. And part of the reason for that is just the deterrent effect of having one of these agreements in place. And an employee thinks, oh no, now for 1, 2, 5 years, I can't do anything and there's no way around that. Well, that's not necessarily the case. You need to understand exactly what restrictions you're limited to, and if there's any way to get around that. And again, as things continue to become more adverse to restrictive covenants, keep an eye on evolving legislation and things like that. That might give you some legal arguments to defeat some of these. And even if you think a non-solicit potentially covers a workforce or a situation that you're involved in or that you're looking to get involved in, there might be potential defenses. If the geographic or the temporal scope of the restriction is too long, that could give you a defense and an argument. So maybe you're in a position where we really need this workforce. We think the non-solicit is potentially, based on the language, extends to this situation, but maybe it's too broad. Maybe it's unenforceable. That might be a situation where if you're confident in that, you decide to roll the dice or figure out how you can continue to pursue the workforce while positioning yourself to be able to defend any potential claim that the employees breached the non-solicitation agreement, that you've encouraged them to breach the non-solicitation agreement or anything like that. Of course, this is an area where we definitely want to be careful because just to be clear, if you are an employer and you are actively working with an employee to unlawfully breach a non-compete, you could certainly find yourself in some kind of, tortuous interference type of situation where I'm not saying it doesn't happen, but I don't think that's ever a company's goal is to find themselves wrapped up in a situation like that.
Let's continue on that line of thought to the non-compete piece. There's a lot of news swirling around at this point, whether non-competes are all invalid, whether they may still be valid, whether it's up in the air. I know that there's ever-changing rules coming out on that point. The semiconductor industry is really only so big. Some of these key people that you may be interested in are subject to a non-compete. They can't go to a competitor. You're probably a competitor. So what do you do?
Yeah, it raises a lot of practical and legal concerns, as do many of these issues. And the first thing we want to keep in mind when we're talking about non-competes, in particular, non-solicits as well, but it's more of an issue with non-competes since they're more of a target at this point in time. How non-competes are treated right now is both a state and federal issue. And this is rapidly evolving. So this is something all employers in this industry and other highly competitive industries, technological industries where non-competes are prevalent will need to stay on top of. The first thing you want to do is you want to understand what's going on in the state where you are, where the employee who you're thinking of hiring is located and where you're located. This is still a state issue. State law varies on a state by state level, and it can vary dramatically. California, for example, non-competes are basically straight up prohibited. You can't have them. California's even gone so far as if an employee signs a non-compete somewhere else and then moves to California, arguably that invalidates the non-compete. So that's something where you need to be very mindful. Basically, employers need to be very mindful of the state restrictions among states, even if it's not a state where you're currently operating, because in that California example, it can still have ramifications for your business. New York also recently had a law that was passed, I believe, where they were going to outright ban non-competes with only very limited exceptions. That was not signed by Governor Hochul. This might be going back about a year now, but at the time she did indicate, there was some support for some kind of legislation like that, although I believe the problem was that the belief was, as drafted at least, it went a little too far. So this is a rapidly evolving issue among states. Some outright prohibit them, some regard them with some skepticism, and others are more willing to embrace non-competes and are not afraid to let companies via legislation know that it's a relatively safe location as far as non-competes are concerned. The problem is, though, even if we're happy with where we land on from a state law perspective, we still need to, at least at this stage in the game, be aware of any potential federal restrictions. For a very long time, non-competes and non-solicits as well were a state law issue. The federal government recently waded into those waters with the FTC's non-compete rule that would have broadly banned non-competes across the nation. It would have grandfathered some non-competes in for senior level executives, but as of the effective date, it would have largely banned non-competes except for those entered into with the sale of a business. That rule, however, has been struck down. It is not currently effective. So I think all employers breathed a huge sigh of relief when they heard that, especially in competitive industries such as the semiconductor industry and other technological industries. But that's not the end of the story. There were actually multiple challenges to the rule. Some won, some didn't win, some were kind of in the middle. And there are at least two appeals now, one in the 5th and one in the 11th Circuit, that are challenging the defeat, for lack of a better term, of the FTC's rules. So a couple companies brought challenges to the FTC's rule. The courts agreed with the companies and joined the rule on a national level eventually, basically right before it went into effect. So everyone was kind of scrambling to figure out how to deal with that. But even though there is a state or a countrywide, nationwide injunction right now, these two pending appeals have the potential to alter that. So not only was the court decision with the nationwide injunction appealed, there's another related case down in Florida that's being appealed. And the thought is that potentially it could result in eventually a circuit split that could reach the Supreme Court. So we might find a situation where We might not necessarily have any clarity with the circuit courts, and they might call on the Supreme Court to give us an overall decision here on whether or not this federal law will remain in place. Or I'm sorry, the federal rule that would strike down the non-competes would remain in place. So as of right now, it's a state issue. In locations such as New York and many other states, you can have non-competes. They're still valid and enforceable. From an onboarding and hiring perspective, we still need to worry about those. We still need to elicit from employees whether they're subject to those. And if they are, we need to take a very careful look at them before we onboard anybody, and especially in a position that would cause them to compete with a former employer. But there might be some further developments on a federal and state level that could greatly affect that analysis, in the coming months or years here. So a very big to be determined, and keep your eyes out and see how things unfold in regard to the overall enforceability of non-competes in the future here.
Thank you, Andy. I don't think I was even totally aware of the difference between non-solicit and non-compete until we got into this conversation. So just fascinating. I'm going to back up a little bit about it's just Elizabeth's idea, and I want you to tell me why it wouldn't work, because I'm sure it won't. But my hiring situation at my own company, we hire employees often from India. And in India, the relationship that employees seem to have between their former employer and their new employer is very different than the US. In the US, I feel like 2-week notice is like totally common. And sometimes when you give your 2 weeks, they have you leave immediately. In India, what I've seen is a lot of times it's more like 3 months. Is it possible that in a situation where you're trying to get employees to maybe move to a totally different part of the country because of the skills that they have, would it be possible to sort of hire people and say, I want you to work next year for my company, and I'm giving you time to like get your life in order and move out to, let's say, New York to work at this new fab, and just that, and you can decide maybe yourself when you want to let your current employer know. I assume that wouldn't work, but I don't know why. So I'd be interested in knowing your thoughts on that.
Yeah, that's an interesting solution to the situation. I don't see a ton of legal impediments to that, assuming these employees aren't subjects to non-competes, non-solicits, or anything that would cause any problems there. I don't see any real, legal restrictions. And actually, from the standpoint of the employer, I mean, obviously part of the discussion here is in a lot of these situations, we want talent now or very soon, and we need to hit the ground running. So that won't solve that problem. But from an employment perspective, it would also give you more time to kind of get your ducks in a row and look at some of these things and alleviate some of the problems that come with having to onboard such a large workforce in such a short period of time. I do see some practical problems there, however, particularly if they're high-level employees or have specific skills or experience that are highly sought after. I mean, you can certainly get an employee lined up and get them in agreement and get them on board. But what I would be worried about is the changing circumstances. What is their current employer doing to try to keep them engaged with the workforce? Do they learn of the arrangement sooner than we would like? And does that give them an opportunity to kind of, end around us and maybe make the employee's situation a little greener at the current company, which could cause problems for us? And not all employees are subjects to non-competes, non-solicits, confidentiality agreements, and things like that. But this could give them, it could open a window for, okay, so we'll give you the promotion and the raise you've always wanted, and now we're going to need you to sign this non-compete and this non-solicit. And next thing you know, we can't hire the employee that we wanted, and we've been waiting 6 months, and we haven't been engaging in other recruiting efforts, and now we're kind of back to the drawing board. So legally, I think it's a good idea, and it gives you some time to get your ducks in a row. Practically speaking and competitively speaking, I think it could pose some problems.
I mean, that's certainly what I have actually seen in the India hiring that I've done, is that sometimes people agree to come and then they sort of shop around, right? Or at least that's the worry. I haven't personally experienced it with any hires I've had there, but that's the concern that I've heard from my recruiting team is, just because you got someone doesn't mean you'll actually get them. It's totally possible that 2 months from now they will pull out and have found something better. I mean, it kind of puts the employees in a position of power, which is interesting, but, it does put the companies potentially at risk. Although in the situation we're talking about here, where you're trying to kind of move a whole lot of people across the country, it's interesting to know that at least from your perspective, it's not legally a problem. It's just more logistically a problem.
Yeah, and I think that's a good point, because here in the U.S., kind of to your point, it's the concept of at-will employment for almost all employees except those subject to an employment agreement, which generally we see, C-suite level and higher level employees like that. So I think the concept of at-will employment kind of makes that difficult, right? Because to your point, it gives the employee the ability to, if they would like, to shop around. It's not traditional to have, 3 or 6 month transition period or, ramp down period with their current employer. So we might be giving the employee a little more power. And then at that point, the way I understand the situation, they have an offer in hand or something similar to an offer in hand. And then, you are giving the employee some power. They can shop around. They can use that as leverage with their current or former employer and see what they can get out of it. And especially in a highly competitive industry like this, where there's only so many employees who can only do so, to fill so many amount of jobs, that could be that would be something I would be thinking about if I was thinking of engaging in the kind of onboarding process that you suggest occurs more often in India.
Andy, what about remote work? I mean, clearly some of the work that would need to be done in a fab requires a person to be physically there. And there are a lot of teams within a new organization, maybe the HR team, for instance, or the legal team, where it's not really a requirement that they necessarily be on site. And we're all pretty used to working remotely. We got used to that during the pandemic. Do you see that as a potential solution to some of these labor shortages?
Yeah, I think that's a great solution, Elizabeth, for employers to look at. But I think they need to do that with open eyes and know what they're getting into. And in a situation like this, where we're trying to ramp up and onboard, I mean, yes, it could be a very efficient solution, particularly for getting highly sought after employees from different locales who, might not be willing to just uproot their lives and move. Somebody might not want to uproot their family from California and move to snowy New York, for example. I could understand that. But I think people or companies in particular, and their HR teams and administrative teams need to be aware that they are potentially opening up a can of worms when they do this. It's certainly something that can be dealt with, but it takes time and effort and intentionality to make sure you're doing it the right way. So basically, take, for example, if you're a New York employer opening up one of these manufacturing facilities or what have you, to your point, a lot of your boots on the ground type workers will probably be drawn from the local economy or will be recruited to come and work out of your facility. For the people you can attract remotely, it's a great tool to try to attract additional talents, especially now post-COVID. Remote work is something that's highly sought after by a lot of people. But what's going to happen is if you hire a remote worker in Florida, for example, let's say, next thing you know, you are now subject to, in all likelihood, Florida law as it relates to your relationship between you and that Florida employee. Florida law can be very different than New York law or California law or what have you. And actually, Florida is a pretty generous example, because in Florida, employers are it's a little more employer friendly. So you're not subject to quite as many of the same restrictions as you might in other locales. But what's going to happen is if we just open it up to a nationwide workforce and say, okay, we need to attract the best talent we can. We don't care where they're located. We certainly can do that, but we might find ourselves in a situation where we are now subject to the laws of 50 different states. And that can create a pretty significant headache, because requirements can vary drastically among the states. Some states might have requirements that other states don't. For example, in New York, when you hire an employee who's not an exempt employee, so any non-exempt employee, which would be presumably those working in the factories and things like that, you have to give them a pay rate form that notifies them of specific statutory criteria. That's not required in all states, but it is in New York. And if you don't, you can be subject to fines, penalties, and enforcement actions. And that's just one example. There are hundreds of examples of different requirements in different states that could be triggered even by just employing a single employee there. And that's not even touching on the tax issues that can arise. Are you withholding appropriately? Are you aware of your tax withholding requirements in these other jurisdictions? is hiring the employee, particularly if there's going to be some more significant presence there, like if you're opening even just an office location or something like that. Do you now have a requirement to qualify to do business in that state? So there's a lot of different legal and administrative issues that would need to be thought of and tackled, particularly if you aren't just hiring from one or two specific states, if you're looking at more of a nationwide approach.
Andy, setting aside non-solicits and non-competes for a moment, there's other restrictions that a potential hire could be subject to. I mean, for example, they may have obligations regarding confidentiality or trade secret restrictions from their previous employer that impact their ability to work with certain technology at a new employer. I mean, what are some of the other restrictions that you'd see for a potential new hire or a key or essential new hire that you're trying to bring on board quickly and efficiently?
Yeah, that's a great point. I think what we need to be aware of is these can come in many different packages and they can be called many different things. But what I'm going to refer that to them as are basically confidential information agreements and intellectual property agreements. They could be combined into one. You might see one or the other, but it doesn't really matter what it's called. You really need to take a look at the agreement and see what it is and what it says. And just to kind of take a step back here, we talked a little bit about non-solicits and non-competes, and how those are generally in most states disfavored, and how the federal tides are even kind of turning against non-competes at least. Confidential information and trade secret protection type agreements don't necessarily come with the same baggage as non-solicits and non-competes, so they might be more readily enforced and viewed a little more favorably, for lack of a better term, by a court or something like that if it's ever called on to enforce one of these agreements. So even though someone's not subject to a non-compete or a non-solicit, doesn't mean there's nothing we need to worry about. We should also be determining and probably including language in our employment agreements, offer letters, and things like that to determine whether or not they're subject to any of these confidentiality or intellectual property agreements. What those will often do is define what confidential information is and do so rather broadly. So that way, if an employee is leaving their former employer to come work with you, they are now subject to a broad confidentiality restriction with regards to a host of different information, client lists, customer lists, employee lists, things of that nature from their former employee that they cannot then come to you and use that information to further your enterprise or further your business as it relates to competing against the former employee. Intellectual property agreements do the same thing. They will actually, in many cases, assign the rights to any inventions that are created during employment to an employer. So if an employee created a whole host of great inventions and proprietary systems that their former employers using, and they did so, in the course and scope of their employment with the former employer, or even just using the former employer's resources and systems, those rights to those, whatever they are, processes, inventions, etc., very well could belong to the former employer. So then if they try to bring those with you, even inadvertently, or bring them with them, even inadvertently, and start incorporating that into what they're doing with you, the new employer, and next thing you know, you not only is the employee going to be subject to a misappropriation of trade secret, breach of contract, et cetera claim, that would almost certainly name you as the employer as well. And then it leaves it between you and the employee to figure out how you're going to deal with that, to really get into the weeds, to see if there has been any misappropriation, to see if it does fall under the restriction, the specific definition of confidentiality or trade secrets or what have you. So just because there's no non-compete or non-solicit doesn't mean we can kind of just bury our heads in the sand and start using information they learned from their former employer to our advantage. We need to be very careful before we start doing that. And just to be clear, a lot of these agreements these restrictions will be basically unending. So they'll be in place, indefinite until the information is no longer confidential. And that generally, in many circumstances, those types of agreements will be enforceable. Just one other thing I would throw out there to add is anyone who's in this situation trying to onboard employees like we've been talking about, even in the absence of an agreement, there are common law restrictions. Common law is what applies in the absence of any contractual agreement. There's common law restrictions on misappropriating trade secrets of an employer. So if employees are unlawfully taking or gaining access to trade secrets and then they approach you with those and say, hey, look at all these great trade secrets I have we can use to our advantage. You need to be very careful about that, because even in the absence of a contractual agreement, even if it's a low-level employee or lower-level employee who's not subject to an employment agreement or what have you, there still very well could be restrictions on that, and you could find yourself facing potential liabilities if you engage in that situation. I think the famous example was, either Coke or Pepsi, someone approached them about selling the other competitor's formula to them, and they, instead of taking up on the offer, they reported it to their competitor. So you need to be very careful before you're thinking about engaging in any kind of that activity.
Well, Andy, thank you for jumping in today to talk a little bit about some of the problems that are deeper than just the initial numbers, because it's clear from the numbers that there is a worker shortage in this sector. But if you're trying to add more people in, the problems actually run deeper. And it sounds like HR folks and labor and employment folks are going to be very busy trying to navigate this as the fabs continue to be built and as they start onboarding new employees.
Yeah, great. Thank you so much for having me. It was a pleasure. Definitely enjoyed joining, and hopefully I'll get to talk to you guys in the future.
Yeah, thanks so much, Andy. I learned a lot from this, so we definitely appreciate having you on.
Great. Thank you so much, Elizabeth and Nathaniel. It was a pleasure.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.